He claimed bankruptcy and thought that meant I would drown with him. I didn't find out from him. Of course I didn't. I found out when my credit monitoring app lit up at 6:42 a.m. with a notification that made my stomach drop before my eyes even focused. Public record. Alert bankruptcy filing detected. I was standing in my kitchen in sweatpants, hair half tied back, coffee barely poured, the house still quiet before my daughter woke up for school. The divorce had been finalized 8 months earlier. The custody schedule was working. The child support, when it came late, but it came. I had rebuilt my budget around tight margins and careful math. Bankruptcy. The word didn't make sense at first. Then I opened the alert and saw the case number. U.S. Bankruptcy Court. Chapter 7, Debtor. Ryan Mitchell, my ex-husband. And underneath his name, a list of creditors that looked disturbingly familiar. Capital Horizon Visa, North Point Auto Finance, Blue River Medical, and then in smaller text that made my hands go cold, joint debt with co-obliger, Claire Mitchell, my name. That was the legal and financial anchor, and it hit inside the first minute of my morning like a door slamming shut. Because Chapter 7 bankruptcy doesn't magically erase debt for everyone attached to it. It discharges the debtor, not the co-signer, not the co-obliger, not the woman whose name was still tied to the credit card he ran up before he walked out. I stared at the screen until the letters blurred. He filed. He listed our joint accounts. And he didn't tell me. Upstairs, my daughter shifted in her bed. The normal sounds of my house felt surreal against the weight of that alert. I opened the court docket online and typed in the case number with shaking fingers. The filing date was 3 days ago. 3 days he knew. 3 days he let the clock tick without warning me. The schedules were public. I clicked. There it was. Schedule E/F. Creditors who have unsecured claims. Our old Visa, $23,418. The car loan we co-signed for his truck, $17,902. A personal loan from 2 years ago, $12,600. He marked them all as joint. And then I saw something that made my chest tighten even more. Statement of Financial Affairs. Recent transfers. He listed payment to ex-spouse pursuant to divorce decree. $8,000. I froze. $8,000. That was the lump sum property settlement he still owed me. He paid it right before filing. My stomach dropped. Because in bankruptcy, payments made within 90 days before filing can be clawed back as preferential transfers, meaning the trustee could demand I return it. I felt dizzy. He didn't just file. He structured it. He paid me, then filed so that the trustee could potentially drag me into it. I grabbed my phone and called Ryan. It rang 3 times before he answered, voice thick with sleep. Hello? You filed bankruptcy, I said. There was a pause, then a sigh. Yeah, he said. I was going to tell you. Going to tell me. When? I asked. After creditors start calling me? Relax, he muttered. It doesn't affect you. I laughed, sharp and hollow. It absolutely affects me, I said. You listed joint debts. That's standard, he replied. It's not a big deal. Not a big deal, I repeated. They can come after me for everything. Ryan's voice sharpened. You got the house, he snapped. You got primary custody. I'm drowning over here. Drowning. As if he hadn't been spending like water was endless. This isn't about the house, I said. This is about you filing without warning me. You always overreact, he said. Bankruptcy wipes it out. For you, I said quietly. Not for me. He went silent. Then he said the sentence that told me exactly how little he understood. Well, I figured you'd file too. I closed my eyes. I didn't claim bankruptcy, and I wasn't going to, because bankruptcy wasn't my failure. It was his. I hung up without another word. The escalation began before noon. My phone rang with an unfamiliar number, a creditor. Ms. Mitchell, the man said briskly, we've been notified that Mr. Mitchell filed Chapter 7. As co-obliger, you remain responsible. Remain responsible. The phrase felt like a verdict. I understand, I said, forcing calm. I need documentation. He said, we'll be pursuing collection activity against you. Collection activity. That meant calls, letters, possible lawsuits, garnishments. The divorce decree had stated that Ryan would assume responsibility for those debts. It had indemnification language. It had clauses that felt solid at the time. But bankruptcy court doesn't care about divorce decrees. The creditor relationship still exists. If one party discharges, the other is fully exposed. I called my divorce attorney, Priya Desai, again. When she answered, I said, he filed Chapter 7. She went quiet for a moment. Did he notify you? She asked. No. Did he list joint debts? Yes. And he paid you recently? Yes. $8,000. Priya exhaled slowly. Okay, she said. We need to move fast. 2 tracks again. 1, protect you from collection. 2, monitor the bankruptcy case to protect your interests, especially regarding the recent payment. What about the debts? I asked. You are still liable to creditors, she said plainly, but you can enforce the divorce decree against him later, if he has assets. If he has assets, he filed Chapter 7. That usually means he claims he has none. I felt the ground shifting under my feet. Priya referred me to a bankruptcy attorney named Daniel Ortiz. When he called, his voice was calm and direct. Let's get clear, he said. Ryan's bankruptcy discharges his personal liability on dischargeable debts. It does not discharge yours. Creditors can pursue you for the full balance. I can't afford the full balance, I whispered. Understood, he said. But you have options. We can negotiate settlements. We can restructure. We can also evaluate whether any of these debts were misrepresented in the bankruptcy filing. Misrepresented. That word stuck. Also, Daniel added, the trustee may review recent payments, that $8,000 could be targeted as a preferential transfer if within 90 days. So they can take it back? I asked. They can attempt, he said. But we can argue it was part of a divorce property settlement, which can be defended. Defended. Everything now was about defense. That afternoon, I received an email from the bankruptcy court's noticing center. It included a copy of Ryan's petition. I read it line by line. He listed his monthly income. He listed his expenses. He listed his assets. And that's when I felt the second drop. He claimed his income was half of what I knew it was. He omitted freelance consulting gigs he bragged about months ago. He listed a truck valued at $5,000 that I knew he had recently bragged about selling for more. He listed no savings, no accounts receivable, no pending payments. He painted himself as destitute. And yet 2 weeks before filing, he had posted a photo online from a weekend trip in Scottsdale. My hands trembled. He wasn't just filing. He was crafting a story. And bankruptcy is built on disclosure. If he was lying, that mattered. The next escalation came in the mail. A thick envelope from a collection law firm. They had been notified of the bankruptcy. They were now pursuing me for the full balance of the joint visa. $23,000. Payable immediately or subject to legal action. I sat at my kitchen table, staring at the demand letter, and felt something settle inside me. Not panic, clarity. Ryan had assumed I would fold. He had assumed I would either file bankruptcy too, or scramble, or beg him. He didn't know I had learned how to read paperwork. He didn't know I had learned how to build a file. I called Daniel Ortiz again. I think he lied on his schedules, I said. About what? He asked. Income, assets, transfers. Daniel's tone sharpened. If that's true, that's bankruptcy fraud. But we need proof. Proof. I opened my old email and searched for the consulting contracts Ryan used to brag about. I found invoices he forwarded to me last year, celebrating payments. I found Venmo transactions he sent me when he covered his share. I found a screenshot he once sent me of his bank balance to prove he wasn't broke. He had been sloppy because he assumed I wasn't paying attention. I forwarded everything to Daniel. He said, "We can file a motion to examine the debtor under Rule 2004. That allows broad discovery. We can also alert the trustee to discrepancies." Alert the trustee. That felt dangerous, because if the trustee believed Ryan was hiding assets, they could deny his discharge. And if his discharge was denied, he'd still owe the debts, which meant he couldn't escape them, which meant he couldn't leave them sitting on my doorstep like a parting gift. I wasn't seeking revenge. I was seeking balance. The next escalation came from Ryan himself. He texted me late that night. "You're making this worse. I heard you talk to someone." I didn't reply. Then another text. "If my discharge gets denied, I'll have nothing. That means no child support." Think about that. There it was. The threat dressed as logic. I called Priya. "He's implying he'll stop support if I challenge the bankruptcy," I said. She sighed. "He's trying to intimidate you. Support obligations are non-dischargeable. Bankruptcy doesn't wipe them out." Non-dischargeable. That word felt like armor. The creditors continued calling. North Point Auto Finance demanded payment for the truck loan. I reminded them the divorce decree assigned it to Ryan. They said, "That's between you and him." The contract remains. The contract remains. The law is blunt like that. You can rewrite your marriage. You can't rewrite your promissory note. 2 weeks later, I received a notice from the bankruptcy trustee requesting documentation about the $8,000 payment. Preferential transfer inquiry. My stomach twisted. Daniel prepared a response, attaching the divorce decree and showing that the payment was part of a court-ordered property settlement, not a random preference. He argued it was not recoverable. We waited. Waiting became the background noise of my life. Then the 70% twist arrived. It didn't come from a creditor. It came from a quiet email from Daniel Ortiz. Subject, found something. I opened it. Attached was a public UCC filing. Ryan had registered a new LLC 2 months before filing bankruptcy. He transferred intellectual property and client contracts into it. He valued the LLC at 0 in his bankruptcy schedules. 0. Daniel wrote, "If he transferred assets into an LLC before filing and failed to disclose them accurately, that's a problem." A problem. I stared at the filing. Ryan wasn't broke. He was strategic. He moved revenue-generating contracts into an LLC to shield them. He minimized their value. He filed Chapter 7 as an individual. He listed minimal income, and he expected the court to accept it. I felt anger rise, not hot and explosive, but cold and focused. because this wasn't desperation. This was planning. Daniel filed a motion requesting a Rule 2004 examination of Ryan. The trustee, upon receiving our tip and supporting documentation, scheduled an inquiry. Ryan called me furious. "You went to the trustee?" he demanded. "I went to a lawyer," I said calmly. "You're trying to ruin my discharge." "I'm trying not to be ruined by it," I replied. He cursed. He accused me of being vindictive. He accused me of not caring about our daughter. I said one sentence: "I care about her enough to not let you gamble her stability." The examination date arrived. I didn't attend, but Daniel did. He later summarized it for me. Under oath, Ryan was asked about the LLC. He claimed it had no value. He claimed contracts were speculative. He claimed revenue was inconsistent. Then Daniel presented screenshots of invoices and payments linked to the LLC. Ryan stammered. He claimed they were future projections. The trustee asked, why were these not disclosed as accounts receivable or business assets? Ryan had no clean answer. The trustee continued probing. And then came the moment that shifted everything. The trustee discovered that 2 weeks before filing, Ryan had transferred $15,000 from his personal account to the LLC account. He listed his personal account as having only $1,200 at filing. He did not list the LLC account balance. He effectively moved cash out of sight. The trustee's voice, according to Daniel, went very quiet. That appears to be a transfer of non-exempt assets, the trustee said, and a failure to disclose. Failure to disclose in bankruptcy can mean denial of discharge. Denial of discharge means the debtor remains liable for all debts, which meant Ryan couldn't wipe them out, which meant he couldn't leave them sitting on my shoulders. The power reversal started building there. The trustee filed a motion objecting to Ryan's discharge based on concealment and misrepresentation. Ryan's attorney scrambled. They offered to amend schedules. They offered explanations. They blamed accounting confusion. But bankruptcy court doesn't tolerate concealment lightly. Meanwhile, creditors who had been circling me paused when they saw the objection to discharge, because if Ryan's discharge was denied, they could still pursue him. I received fewer calls, fewer letters. Silence felt like oxygen. Ryan tried one more time. He called me late one night, voice stripped of arrogance. "Can we settle?" he asked. "Settle what?" I said. "I'll take responsibility. I'll refinance the truck. I'll work out payment plans. Just don't push the discharge denial." I sat at my kitchen table, looking at the stack of letters he had let hit my mailbox. "You filed without telling me," I said. "You listed joint debts. You moved money. You hid assets. And you think this is about me pushing?" He went quiet. "I was scared," he said finally. "So was I replied, but I didn't lie." The hearing on the discharge objection was short and sharp. The judge reviewed the trustee's findings: transfers before filing, failure to disclose the LLC assets, inaccurate income reporting. The judge's voice was steady. "The debtor's lack of transparency undermines the integrity of the bankruptcy process," she said. Then she delivered the sentence that ended Ryan's plan. "The discharge is denied." Denied. It wasn't dramatic. It wasn't loud. It was a legal conclusion. But it changed everything. Ryan walked out of that courtroom, still owing his debts. He couldn't hide behind Chapter 7. He couldn't leave creditors knocking only on my door. The creditors, seeing the denial, redirected their attention back to him. Some continued pursuing me for joint liability, but now I had leverage. I negotiated settlements on 2 accounts for reduced amounts. I refinanced the truck into my name only and forced its sale. And most importantly, I enforced the divorce decree. Priya filed a motion to compel Ryan to indemnify me for any payments I made on joint debts. The court, seeing the bankruptcy denial and the concealment findings, didn't hesitate. Ryan was ordered to reimburse me for negotiated settlements and attorney fees. He was ordered to remain current on child support under threat of contempt. And because of the concealment, the judge awarded me additional attorney fees. Ryan didn't like that. He told me at a custody exchange, "You've made my life hell." I looked at him and said quietly, "No, you did." Months later, my credit report stabilized. The joint visa showed settled. The truck loan showed paid. The personal loan was resolved. The bankruptcy case remained open longer than Ryan expected because the trustee examined the LLC assets further. But the central fact was clear. He claimed bankruptcy. I didn't. He tried to drag me under. I didn't let him. One night, as I tucked my daughter into bed, she asked, "Mom, are we okay?" The question cut deep because she didn't know the details. She just felt the tension. "We're okay," I said, smoothing her hair. "We always find a way." After she fell asleep, I sat at my desk and thought about what bankruptcy really means. It's supposed to be relief, a reset, a legal fresh start. But it only works when it's honest. Ryan tried to use it like a shield. He tried to use it like a weapon. He assumed I would either follow him into it or collapse under it. But here's the truth I learned the hard way. Joint debt doesn't disappear because one person files. Divorce decrees don't rewrite contracts. And silence doesn't protect you. Documentation does. Deadlines do. Objections do. When someone claims bankruptcy and you didn't, you have a choice. You can panic, or you can learn the rules faster than they do. I learned the rules. I learned that trustees care about disclosure. I learned that transfers matter. I learned that concealment has consequences. I learned that support is non-dischargeable. I learned that indemnification is enforceable. And I learned that calm voices in courtrooms can do more damage to lies than shouting ever could. Ryan thought Chapter 7 would wipe his slate clean and leave me holding the chalk. Instead, it exposed him. And once exposed, the system did what it's designed to do. It corrected. He claimed bankruptcy. I didn't. And that difference, that refusal to surrender my stability to his panic, is the reason I'm still standing in this house, paying my bills, building my credit, and teaching my daughter that when someone else makes a mess, you don't have to drown in it. You document it, you challenge it, and you let the truth carry the weight they tried to drop on you.